So again, welcome to Title IX for K-12 schools in California, Answers for Campus-Based Preventionists. We're here on Monday, November 9th. This web conference is 90 minutes, and we are excited to be kicking this off with our presenter today, Janet Neely. Go to the next slide. I know we're all Zoom experts by now, so just a couple notes very quickly on how to use Zoom. We have closed captioning provided today by our friends at Aberdeen Captioning. Thanks for being here, Aberdeen. If you need to access closed captioning, please select the closed captioning little icon there on your information bar on Zoom. A couple of things regarding web conference guidelines. We will be going through and muting folks if we're getting any background noise. I just like to know or let folks know that that's something that we do if you forget to mute yourself or something like that, that we'll be looking out for that, making sure that everybody can hear okay. And the other thing that I wanted to mention about today's web conference that is perhaps a little bit different than other web conferences that we do is that we're actually really encouraging folks to ask their questions in the order that they come up. We are trying our best today to leave a good chunk of time for Q&A at the end, but we would like to get a good idea of what kinds of questions folks have and what makes sense for Jan to answer in real time as they come up and what makes sense to hold to at the end. So please go ahead, if a question pops into your head, throw it in the chat. We'll make sure that that gets collected. If we don't answer it right away, know that we will be coming back to that at the end. We just wanted to save time a little bit to get folks with their questions coming in, and you never know, perhaps it'll be answered in another point of the web conference as we go along. But yeah, please answer, or rather drop your questions in the chat as they come up, as you have them on this web conference. We will be going through a lot of content today. So we want to make sure that everybody who has questions about these new Title IX regulations is able to ask them and get them answered. I know that this is something that has been on folks' minds for a long time. So we're excited to be able to be here today and get some of those questions answered for y'all. The other thing that I want to mention, and we did say this in our registration announcement emails, is that this isn't a Title IX 101 webinar. CalCASA has done a number of those already, which we sent to you in the registration announcement. But I just wanted to state that again for folks who perhaps didn't see or overlooked that we're really going to be diving into the specific changes to Title IX for K through 12 schools. We're not really going to be doing an overview of what Title IX is or what the past regulations were, anything like that. So this is, I'm not going to say like it's terribly advanced. We still really encourage you to stay on with us, even if there's not a whole lot that you know about Title IX, but we did just want to say out loud that it's not a super basic introductory level webinar to Title IX. So for your information, go to the next slide. So CalCASA is on Facebook and Twitter and Instagram and all of the places. Please follow us on social media. And for any questions for after the webinar or training and technical assistance requests, you can go ahead and send us an email at info@calcasa.org. The folks that are on the web conference today, we have myself. My name is Sarah Orton. I use she, her pronouns. I am a project coordinator on the Rape Prevention Education Project at the California Coalition Against Sexual Assault. I am joined by my colleagues, Jessie Town-Cardenas and Meghna Bhatt. I will let them introduce themselves in one moment. I want to flag myself as your tech help for today. So if anybody is having any issues, accessing audio or other technological features of the web conference, Meghna and I are your people. So please go ahead and send us a private message if you're having any issues with that. Jessie and Meghna, would you like to say hello?
Sure, I'm Jessie Town-Cardenas and my pronouns are she, hers, and I'm a consultant with CalCASA. And I'll be monitoring questions in the chat. So if you also need to send a private chat, feel free to chat me about non-technical issues.
Hi, good afternoon, everyone. My name is Meghna Bhatt. My pronouns are she, her, hers, and I'm a project coordinator on prevention at CalCASA, and I'm excited to be here. Thank you.
Thank you both. We can go ahead and skip to the next slide. And like I said before, on this web conference, we are joined by legal consultant for CalCasa, Janet Neely. And I will go ahead without further ado and hand it over to Janet so she can get us
Thank you,
started.
Sarah. Hi,
Yeah.
everybody. Thank you for coming today. We will do a little bit of basic overview, not much of Title IX, and certainly not a lot about the new regs, but I'm very happy to say that the Biden administration or incoming administration has announced that one of their priorities is going to be working on the regs. It's not as easy to overturn regulations that have been enacted formally, like the new regulations were, as it is to get rid of a dear colleague letter. So it probably will take them some time to rewrite the current regulations, but I'm happy to say they're going to work on it. So we'll see what they do in the interim with the regs that we currently are working under. I'm not sure there's a lot they can do, but maybe there is. So yeah, we'll recap a little bit about the new regs, and then mostly we're going to talk about the differences between colleges and K-12 schools and focus on how the new regs impact prevention activities that are being developed for K-12. Okay, so here's where we're going. Title IX, how does that apply to K-12 and processes? And just our legal caveat that we always give, I can't really give you legal advice because I'm not your attorney, but I'm always happy to talk about what the law is, because anybody can talk about that who knows the answer to a question about what the law is. I just can't talk about how it might apply to a specific client or situation. So we're going to start with a quick audience poll. What do you feel like your level of knowledge is about the new K-12 Title IX regulations? And Sarah, you're doing that right.
Sarah, you're muted.
Yeah, sorry, I saw that. Yeah, just give me one quick sec. I'm having just a quick freeze up over here. Sorry for the delay, y'all. Can y'all see that on your screen? I was having a bit of a spinning wheel of death situation.
Luckily, you overcame it. It's not always that easy.
Great. So I see, yeah, that these results are coming in quick. We have about 68% of folks who have voted. So if you have not voted, please do so. We will be closing this poll in just a moment. Again, to reiterate the question, we would like to know, what is your level of knowledge about the new K-12 Title IX regulations? We have good, fuzzy, or poor. I'm going to go ahead and close out the poll in about 5 seconds. So if you haven't voted, please do so now. Go ahead and close the poll and you should see those results on your screen now.
Okay, well, it's good. We're going to do a little overview then. And then we're going to talk in detail about the differences and similarities between the new regs and the K-12 and college, obviously. All right, great. Okay, so now it's not letting me advance the slides though, for some reason. Here we go. All right, so everybody knows this basic definition that Title IX is founded on. No person shall, on the basis of sex, be denied participation in or benefits from or subjected to discrimination in educational programs or activities receiving federal financial assistance. So that's the basic definition. And the stick is, of course, any school has to be getting federal financial assistance, which is most colleges and universities and most K-12s. So there's a few schools that have tried to take themselves out of that, but not many. So the new standard in the new Title IX regs that took effect in August for Title IX violations for sexual violence, which includes sexual harassment, is based on old Supreme Court, US Supreme Court case law. For student-on-student sexual harassment, the school is liable when the school has actual notice of the harassment and the response is deliberately indifferent. Harassment must be so severe, pervasive, and objectively offensive. And of course, those are loaded terms that are decided in a case-by-case kind of way. The institution's indifference was systemic. So this standard is quite a bit higher than the prior standard before these new regs took effect. Deliberate indifference is defined as clearly unreasonable in light of the known circumstances of the particular situation. And this is codifying this case from 1999 from the Supreme Court. The new definition of sexual harassment in the regs says that it is conditioning, providing aid, benefit, or services by an institution of education, but this would also apply in K through 12, on an individual's participation in unwelcome sexual conduct. That's what we call the quid pro quo provision. Or it's unwelcome conduct that is reasonably determined to be so severe, pervasive, and objectively offensive that it effectively denies a reasonable person's equal access to a school education program or activity. So those are the bases. They're both just like the way we determine what's reasonable or not, both higher standards than we had under the prior regs. Educational program or activity has been narrowed. So under the new regs, it means locations, events, or circumstances where a school exercised substantial control over both the respondent, so the person that's alleged to have perpetrated the conduct, and the context in which the sexual harassment occurred. So this is another way in which the regs that came out in August narrowed the scope of Title IX as it applies to schools, because now the school has to be exercising substantial control over both the educational program or activity and the respondent, which is interesting. Off-campus sexual assault is very likely to impact a student in how they experience their education on campus. California law requires higher education institutions, so not K through 12, but colleges and universities, to address off-campus sexual assault, domestic violence, dating violence, and stalking. But because the California law wasn't drafted to apply to K through 12s, there's no state law requirement in California that schools adjudicate grievance processes concerning off-campus conduct, unless it was in the context of a school educational program or activity directly. So that's a big difference. California law steps in and fills the gap that's now been created about off-campus sexual assault by the new regs for colleges and universities, but not for K through 12 schools. Now, the law could be amended in California to recognize this gap and to require K through 12 schools to address sexual violence that impacts a student's ability to get an equal education. But that would mean new legislation would have to be proposed in the next session. A K through 12 school of conduct can be broader, though, than the Title IX definition of unwelcome conduct. So, for example, a K through 12 school could impose its own sanctions for unwelcome conduct, and they could have a lower standard than it being so severe, pervasive, and objectively offensive as to deny equal access. They would do that, and then they would have hearings or at least administrative grievance processes to address the conduct under their own conduct code, but it would not be a proceeding under Title IX. If the school chose to do that, the K through 12 school could address student conduct, sexual harassment that occurs off campus that's not in the context of a school program or activity. if it's impacting the way that a student is going to be able to experience their education on campus. And it just means it won't be a proceeding that's held under Title IX guidelines or regulations. So if the school ultimately determines that there is no Title IX jurisdiction because it's not in the context of a school program or activity and it's off campus, they would have to dismiss any Title IX complaint that they originally filed and then proceed under their own conduct code. Colleges are using this type of dual system. A lot of the new disciplinary rules that have been written in light of the upcoming enactment in August of the new regs took into account the fact that the Trump administration significantly narrowed the ability of Title IX to address sexual violence and sexual harassment in a number of areas, and have enacted dual systems for addressing sexual assault. For those that fit within the more narrow Title IX guidelines, you can still have a Title IX proceeding. For those that don't, you have another grievance proceeding that has its own rules set up by the school. Okay. Both colleges and universities and K-12 schools have to have a Title IX coordinator. So there's no difference in the regs, in the requirement for that. Schools are now required under the new regs to widely disseminate contact information for their Title IX coordinators and for the accommodations and services that they provide under the new regs. And under the new regs, the Title IX coordinator can assist with investigations and can file a Title IX complaint, but the investigator, the decision maker, and any appellate decision maker have to be separate persons. So no longer can the Title IX coordinator investigate a complaint and then issue a preliminary decision what happened. They cannot be the arbiter or finder of responsibility anymore if they're participating in the investigation. And that's true on K-12 campuses as well as college and university campuses. Okay, I'm moving to alternates to conduct system proceedings, which can be used in both K-12 and college and universities. So restorative justice is the most usual type of alternative system for adjudicating or helping resolve sexual harassment and sexual violence issues that arise. And a few K-12 schools in California are using restorative justice processes, and they can continue to do that under the new regs. In order to use a restorative justice process, both the complainant and the respondent have to agree at the very beginning of the process that they both want to proceed in that manner, and the respondent must be willing to admit responsibility from the outset of the proceeding. So restorative justice processes focus on the harm caused to the parties and specifically the harm caused to the complainant. So there's less focus on proving that the respondent did it because they start out with the admission that they in fact perpetrated the harm. And it's more of a focus on what happened, the story of what happened to the survivor, who has a chance to explain his or her side of the story, and the wider community, because often sexual harassment and assault impacts more than just the survivor, although she or he experiences probably the primary harm, but there are other community members that are often impacted as well. And so restorative justice is trying to focus on the harm to the survivor, first of all, but then to the wider community. So even after a formal Title IX complaint has been signed, K-12 schools can offer an option for the parties to use restorative justice grievance process to resolve it instead of a formal Title IX hearing or process. If the act violated the school's code of conduct, but it's not falling under the new narrow Title IX jurisdiction, the school can still offer alternatives, restorative justice type alternatives. Again, the parties have to agree in writing to use the restorative justice processes, but they can withdraw their consent at any time prior to a decision to that. And if they do, then it's going to go to a more formal Title IX process. Little caveat, restorative justice processes cannot be used when a school employee is alleged to have harassed a student. So if the sexual harassment is by an employee, not another student, restorative justice doesn't apply. And that's true at K through 12 and colleges. So when you are working on prevention materials about the dual system, a couple of the things you're going to have to think about is how you explain in those materials to survivors that they may not have a Title IX complaint anymore, but they still would have a valid, a potentially valid sexual harassment claim that would be processed under a dual part of the student's conduct code. So just because they don't have any rights under the current regs in Title IX doesn't mean that they can't proceed either in a disciplinary hearing or some alternative restorative justice process to have their harms addressed. The other thing to remember when you're drafting materials on prevention is that rape crisis centers, the Title IX office, housing office, student life, all the players on campus need to be collaborating to ensure that students are aware that there are options beyond formal Title IX proceedings, because Title IX, unfortunately, in the last few years has taken on a negative connotation for some students, and they may think that they don't want to participate if that's all there is. And they may actually be encouraged to learn that there are non-Title IX alternatives, either under the school's own conduct code or in the context of restorative justice, if the school offers that. So just a couple of things to be aware of, but of course you've got to know what the school you're working with does offer in terms of drafting, to put out what the alternatives are. All right, so now we're getting into the nitty-gritty of what the differences are between K through 12 and college and universities under the new regs. In the new regs, in a K through 12 school, and it's under a Title IX formal proceeding, if parents have existing legal rights granted by state law over that child, the child who's the complainant, either they have a court order, a custody order, or they're they are the parents living with the child or who have custody over the child, either one, the parents can request supportive measures for a survivor. The parents can participate in the grievance processes, including going with the student to meetings, to interviews, and to any hearing, and they can exercise rights on behalf of the student. They also have the right, the parents do, to inspect and review written evidence. So the regs don't really address, well, what's going to happen if the student, who's a minor, doesn't want to respond or react in the same way as their parents do. And I think that's a really interesting question that you might have, but the regs don't really answer that. The regs also say that the student's advisor for the Title IX proceeding may be different than the parent or guardian. So under the new regs, if you're going through a formal Title IX proceeding, everybody's entitled to have an advisor appointed, and the school has to appoint one if the student doesn't have one of their own. A lot of times at the college level, that means that the respondents are lawyering up, and the survivor may or may not be able to afford her own or his own legal representation. If in that case, the school, the college, has to appoint an advisor for that person. At the K through 12 level, that same rule applies. The school is going to have to appoint an advisor, but if it's a parent or guardian who wants to assume that role, I'm assuming you have to let them. And again, the regs don't say, well, what if the student doesn't want their parent to be their advisor? What does the school do then? Doesn't address it. When a complaint is filed against a minor in who's or any student in a K-12 school, the parents have to be informed that a complaint has been filed against that respondent. And when parents have legal rights over a minor, they can file a complaint with the Title IX coordinator on any Title IX issue. So it could be athletics or other discrimination situations, as well as sexual harassment. So that's very different than the college situation. This is only at K-12 schools. So when you are working on materials in a K-12 situation, really what you need are the school to have multidisciplinary action teams working on the new policies and protocols that are going to inform the prevention materials, because you have to know the rules about the parental roles in the K-12 context in order to draft policies and protocols that go along with what the rules are. And I think that probably the new regs are going to require a lot of K-12 schools to enact new rules about parent participation in these proceedings. Under the old law, the person that students thought might have had the ability to help them to redress an act of sexual violence, anybody in that role that students could reasonably have thought could help them with that, had a duty to report to Title IX if a student revealed to them that they had been subjected to sexual harassment or sexual assault. Those people were called responsible employees under the old regs, or the old law. It wasn't really regs before. Under the new law, in K-12 schools, and this is the major difference with colleges and universities, a report to any employee of a K-12 school constitutes actual notice to the school of the sexual harassment, sexual violence. So that's a big difference. In colleges and universities now, only reports to people who have the authority given to them by the university to institute a corrective measure. Only a report to that person, meaning the Title IX coordinator or somebody else formally designated by the school to be in that position, gives actual notice to the school. So, for example, if you have a student at college tell a faculty member, under the old rule, the faculty member would have had to report that to Title IX. If they failed to do that, the school would still be implied to have been on notice and would have had to have acted accordingly, and they could be in trouble, even if it was never reported to Title IX. Under the new regs, no more implied notice when a responsible employee doesn't report. We no longer have responsible employees, just persons who have authority to institute a corrective measure. So if it never gets to Title IX at the college level, if it never gets to Title IX, the campus is not going to be liable. That's not true at K-12. Any employee, even the janitor, under the new regs, has to report. And if they don't report, the school is still going to be liable. So what the new regs say is that in a K-12 school, notice of sexual harassment can be by a variety of ways. Either somebody tells somebody about it, oral report by the complainant, or a third party, could be by a third party to a teacher about something that happened to a friend. Or it could be a written notice to the school. It either could be a letter, an email, a newspaper article, or an anonymous report. As long as that report, written or oral, gets to an employee of the K-12 school, and it's telling them that one of their students has been subjected to sexual violence or sexual harassment, that's notice. What about social media? If the social media post is brought to the attention of any employee, again, any employee at a K-12 school, so it can be a Twitter, a tweet, I'm sorry, a post on Instagram, a post on Facebook, any other app, TikTok, that is going to constitute actual knowledge to the K through 12 school and require the appropriate response as long as any employee knew about it. This is opening up K through 12 schools to a lot more liability than happened for colleges and universities. So I'm sure campus council are going crazy with trying to figure out how to address that. And it's going to mean a lot of education of faculty and staff at K through 12 schools. So Title IX, the regs don't limit who can report. It can be made to anyone at a K through 12 school and not just by the complainant, but the school's response basically just has to be initially to offer supportive measures. So counseling, class changes, dealing with teachers about assignments, possible no contact orders, all the usual accommodations are required at a K through 12 school, regardless of who made the report. Now, the K through 12 school might offer them to the complainant, but if she or he is not the one who made the complaint, it was done by a parent or a witness or a friend, you know, that person may not want it. But the important part is to document that the offer of accommodations was made. So policies in K through 12 schools should be identifying the available accommodations that can be offered. And the schools should be able to show that they are trying their best to ensure equal access to education, to make the person feel safe, and to deter any further incidents like the one that happened. So the regs, the new regs say that you have to follow the formal Title IX grievance process before you take any actions other than the ones right here on this slide against a respondent. So if an allegation has been made of rape at a K through 12 school against one of the students, the school can offer these accommodations that are listed here, but that's as far as they can go until there's been a finding of responsibility. And so the new regs are trying to shield or protect people who are alleged to be respondents until the end of the Title IX process. And that's true on colleges and K through 12 campuses. So by itself, the report of sexual harassment or sexual violence doesn't trigger an investigation. Either the complainant or their parent has to sign a complaint, or the Title IX coordinator must sign the complaint in order to initiate a formal investigation under Title IX. Title IX coordinator has the same duty at colleges and universities as they do in a K through 12 school, which is to promptly explain the process for filing a formal complaint to avoid the school being found to be deliberately indifferent. So they have to be expeditious about how they handle these. But there's only going to be an investigation if the complainant wants one, complainant's parents on a K through 12 campus, or the Title IX coordinator thinks one is necessary. So there's now two ways to begin a Title IX case, and we just talked about those two ways. But in some circumstances, the school is going to be found to be deliberately indifferent if Title IX coordinator refuses to sign a complaint, or found to be clearly unreasonable. So what are those situations? So here's some examples. If the school has actual knowledge of a pattern of alleged sexual harassment by a perpetrator who is in a position of authority at the school, or the school wants to investigate allegations in order to determine whether there's probable cause for sexual misconduct that's going to affect the school's legal obligations, or a Title IX coordinator gets multiple reports of sexual harassment against the same respondent. Those are the examples that the regs give as to when a Title IX coordinator must sign a complaint. That's, again, true on K-12 as well as college campuses. All right, so here's some other similarities and differences. Regs provide both sides, both parties, an equal opportunity to have witnesses for them, including expert witnesses, and that's new in the regs, and to present either evidence that exonerates or inculpates the other party during the investigation. And the school has to prepare and share with the parties a draft report of the evidence on both sides. So it has to be given to both parties and to their advisors if they have them, either electronically or hard copy. It has to give them 10 days to review that draft report of evidence and any attachments, and then they have 10 days to submit written responses. So 10 days to review and to submit a response. The school has to share any new evidence that comes out to their attention after that report, and continue to investigate if necessary, and then incorporate everything they get, the new information, if any, and the responses from the parties in a final investigative report. So this applies to colleges as well as K-12 schools. Another big difference, though, between colleges, universities, and K-12 is that hearings are optional. So one of the big criticisms of the new process at college and university level is that the hearings are like mini trials now. People are going to lawyer up even more than they were before. Everybody's entitled to a legal advisor. And just the whole process with cross-examination being required is like a trial. So K-12 does not have to have a hearing. The school district's policy now determines whether a hearing is going to be part of the process. In a K-12 school, you still have to give everybody opportunity to submit relevant questions. And even if you're not having a hearing, that would be true. And provide each party with written answers to those questions, and then allow some limited follow-up questions. If there's a hearing, decision makers would have to explain at the time to a party whose question is barred, the reason why they're barring it, why it's irrelevant or duplicative or whatever the reasoning is, although the regs talk just about relevancy. But this is really the big difference, is that K-12 schools don't have to have an in-person hearing. They can resolve it based on written materials.
Jan, I just want to hop in real quick, because I think we could just pick up a few of these questions on the side before you go on to the hearings. It sounds like Terry's question has been answered, that the victim will receive a written report of the findings.
Right.
And then Holly asked, if a survivor does not want a legal caregiver involved at all, beyond just having them as an advisor, can they keep the legal caregiver out of the process?
So the person, the advisor that the school is required to appoint is probably not going to be an attorney, because the regs don't require it, and that's going to cost some schools money. So it's likely they're going to appoint an administrator or a faculty member to be the advisor. But the student doesn't have to accept an advisor. That's totally up to them or their parents at a K-12 school.
Do they have to have their parents involved?
They have no choice under these regs. That, in fact, it looks like the regs give the parents the authority to override the wishes of the student. That's how it looks.
Okay. And what would be considered an appropriate response to a grievance reported? So
it's going to depend on how egregious the conduct was. If it's not you know, it's going to depend. Are we talking about flashing somebody? Are we talking about inappropriate comments that made someone uncomfortable? Are we talking about sexual battery and an inappropriate touching of genitals or breasts? Are we talking about full-on sexual assault, rape, or sodomy? You know, it's going to make a difference what the conduct was. The school has a whole range of options and sanctions they can consider, you know, starting with requiring counseling, requiring participation in alcohol awareness programs, anger management, whatever counseling programs they have available to them, all the way up to suspension and expulsion. So it's totally going to depend on the type of conduct.
Okay, so depending on the type of conduct, could a mandated sexual assault training for staff and students be part of that appropriate response?
Could a training for whom?
For staff and students on sexual assault.
Yeah, well, sure. The school could require the respondent to attend a training. And if they want to include the whole school, they certainly could do that.
Okay.
Mandate, I mean, K-12 schools have a lot of scope and leeway to mandate students to go to an assembly on pretty much anything they want to, right? So they could certainly require them to go to an assembly on informed consent or sexual assault in Title IX.
Okay. And then the last one I'm going to pick up for now, though we have the others, is does this also apply to non-sexual instances of teen relationship violence?
So it does apply to dating and domestic violence and stalking, as well as sexual assault.
Okay. Thank you.
Okay. All right. So hearings. So if a K-12 school has the option of whether or not to have hearings as part of their Title IX process, first of all, they're going to have to make a blanket rule. Either they are going to have hearings every time, or they're never going to have hearings as part of their process. It can't be, okay, this one we think needs a hearing and that one we think we're not going to do a hearing. It has to be a blanket policy. But when might they decide that they want to include a hearing as part of their proceedings? Well, if it's a high school, they might decide that they think a hearing would be helpful. Or if it's a school with students over a certain age, they might be able to limit it to that. So they might say, we're not going to have hearings for K through 6, but we are going to have hearings for 7 through 12. You know, so it gives a K through 12 some leeway in deciding which, if any, students will have to go through a hearing as part of the process. But both parties have to consent and request it. So that's a little caveat there. In other words, even if a school thinks it would be a good idea for all proceedings to have a hearing, the regs give the consent for that to the parties. So if only one party wants a hearing, let's say the respondent, and the complainant does not, then the regs prohibit having a hearing. This is, again, just K through 12, because hearings are not anything that there's any discretion about at the college level. There has to be a hearing if there's a formal Title IX proceeding. So let's say both parties want a hearing and the K through 12 school policy has permitted that there be a hearing. Do the Title IX hearing rules, which are quite specific, apply at a K through 12 school? So the Title IX regs on hearings only apply to colleges and universities, which means that K through 12 schools have a lot of discretion in designing their own procedure for the hearing. So for example, at the college level, they have to follow the Title IX rules for a proceeding, and there has to be cross-exam. At a K through 12 school that's going to allow hearings and the parties both want a hearing, the school could ban cross-examination. But again, that would have to be in policies that have been put in place to apply to everybody in this situation, not just for one particular individual case that comes up. Okay, I hope that's clear. It's a little, it gets a little complicated. Now, I talked about the fact that both parties can submit questions to the other side through the school's investigative process. Can parents control what the students' questions are that are submitted? And again, the regs are totally unclear about this. They acknowledge that it's an issue, but they don't say if the parent must consult their child about the questions or about any answers that their child may submit to the other side's questions. So the comments to the regs, which are not formal law, but they're just commentary about disputes between parents, say the school needs to establish rules of decorum, such as requiring questions to be posed in a respectful manner. So that doesn't really answer the question about, well, what if one child, let's say this kid here is the respondent in this photo, his dad thinks that he should say one thing and his mother thinks that the answer should be another thing. What is going to happen, and what's the kid supposed to do? And I mean, the parents are allowed to respond on behalf of the kid too. So whose response is going to count? It's really a mess. If you ask me, it's a hot mess when it comes to K-12 schools. Now, survivors often make a statement to an investigator that is transcribed and recorded at the beginning of the proceedings. And so the question arises of whether that lengthy statement that's usually taken can take the place of submitting written questions. The regs are not clear on whether written questions that are provided by the other side can be presented orally by the investigator instead of each party being required to submit questions in writing and expecting a written answer and response. So that's not clear either. And so my point would be that the schools need to make this clear in their own policies and procedures, so everybody knows either yes, there can be an interview where questions from the other side are asked by the investigator and there's an oral answer, or no, we're going to require written questions and written answers. The schools need to address that issue. Schools are permitted to provide training to investigators about effective interview techniques that apply to children, which that comment in the regs implies that questioning can be oral rather than in writing, but again, we don't know for sure. So under the old rules for Title IX, schools often ordered the parties not to discuss the case during the pendency of the investigation. The new regs prohibit what they call gag orders, meaning that they're not allowed to tell people not to go and tell all the witnesses and friends to the incident about it. They can go do that, which of course creates some problems. But gag orders are prohibited for both K-12 and institutions of higher education. So schools, K-12s, as well as colleges, must include in their policy and in their written notice of a complaint a statement that there are no restrictions on the ability of any party to discuss the allegations or to gather and present relevant evidence, including presenting experts. So I don't like this. A lot of schools don't like this. The whole idea was to be able to interview people quickly who were witnesses without them being coached by somebody who was there on one side or the other before they could be interviewed by Title IX investigators or the police. Now, because you're not allowed to ask them not to talk to anybody, they can go tell anybody they want, which is problematic. This is definitely going to be something that's changed when these regs are rewritten, I predict. So the new regs allow schools to do an emergency removal of a respondent from the campus before any hearing. And I think that that would include before any kind of disposition, even if there's not a hearing at a K-12 school. And any rules adopted by schools that aren't required by Title IX, so the dual system of conduct that I was talking about, if something doesn't fall under Title IX, still has to apply equally to both parties. So the regs basically say, well, you can have your dual system even if your idea of sexual misconduct affecting somebody's ability to get an education falls outside of Title IX, but if you do adopt additional rules, they have to apply to both sides. All schools have to follow whatever their grievance process is before imposing any disciplinary sanction that is not one of those described supportive measures that I talked about earlier. There's new training requirements, and these apply both to K-12 schools as well as college and universities regarding training investigators, Title IX, people who are making decisions on the initial complaint or any appeal, and facilitators if they're using restorative justice resolution processes. So the mandated training topics are the definitions in Title IX, what is the scope of the college or university's programs or activities. So here it would be K-12, how to conduct an investigation, a hearing, or to do restorative justice resolutions, and how to avoid prejudgment, conflict of interest, and bias, because the people who wrote the new regs are sure that there's a lot of bias going on against respondents. There also has to be rape shield law training on what it means in the K-12 setting as well as college. The rape shield law still applies, and what the meaning it is of relevance. So really it's like a mini legal training for people working in this area on privilege, relevance, and rape shield law. So that's a pretty narrow little area requiring training, but it does apply to K-12 as well as colleges. Now, affirmative consent is still governed by California law, but California law has written affirmative consent into the processes for colleges and universities globally. It applies everywhere as long as the school is getting California financial support. They have to comply with California's broad definition of affirmative consent. K-12 schools, on the other hand, are governed by a different law than colleges and universities in California. So California law says K-12 schools have to teach affirmative consent only if health education is required for graduation. So the new regs in Title IX don't change the affirmative consent standard, and the standard is similar to California's, although it's not quite as detailed. The California definition is consent is both by both parties, affirmative, conscious, and voluntary. Everybody makes sure they have the consent from the other person, and it doesn't have to be verbal. So K-12 schools are still going to have to use this standard, but they still don't have to teach it unless under California law, they're requiring health classes for graduation. So burden of proof on consent under the new regs say it's not the respondent's burden to prove consent. If there's a hearing, or if we're talking about written questions, either one, the respondent can ask questions and present evidence even under the rape shield exception, or rather under the rape shield law. The exception is they can ask about the complainant's sexual history if they're arguing somebody else is responsible for the sexual assault. So rape shield law means you can't ask a complainant about their sexual history, but the exception is if the respondent's arguing that somebody else did it, then they're allowed to ask these questions. The burden of proof remains on the school to establish or prove that there was or wasn't consent. And that's not a change. That was always true. Schools have to appoint separate people to serve as investigators, decision makers, appeals makers, deciding appeals, Title IX coordinator, and advisors. So these roles have to be separated out. In the past, a lot of schools combined some of these, like investigator, decision maker roles, no longer permitted. And that California case law in the last couple of years is in agreement with this, that you really can't have an investigator deciding. So that part of the new regs, I'm guessing, probably won't change. California case law, yeah, agrees with that. Investigators should not be adjudicating guilt. So confidentiality, investigator, I'm having a problem with that word. They can't, those people, investigators, can't obtain, access, consider, or use records maintained by a health or mental health professional. So counselors can't be required to turn over the records from one of the parties to people who are deciding guilt or innocence or responsibility here in these proceedings. And of course, that applies to rape crisis center advocates as well, who have a privilege. There has to be written consent. So this is based on a University of Oregon case where the school demanded, in order to defend a lawsuit against them by the complainant, that the school counselor turn over her notes from her private sessions with the student who was the complainant. And the new regs do say schools can't do that. This applies in K-12 as well as colleges. The providing all the parties 10 days to review the draft investigative report. That's K-12 and colleges. All have opportunities to inspect and review the evidence directly related to the allegations. Well, what does that mean? Evidence, there can be a lot of things that a complainant may tell an investigator, and some of that may be completely irrelevant. She may tell the investigator about past sexual assault experiences that have nothing to do with the current allegations. So the evidence that has to be turned over to the respondent has to be directly related to the allegations, not everything that she said to the investigator as part of the process. Unfortunately, though, the new regs also say they have to include any evidence the investigator does not intend to rely on in the written investigation report prior to finalizing the report. So that's kind of contradictory to what I just said, right? They don't have to let them review evidence unless it's directly related, but then even if the investigator isn't going to rely on it, they have to give them an opportunity to see it. Well, so that sounds like they're saying there could be things that the complainant may say that he doesn't need to know about if he's the respondent, that they have to turn over. So this is definitely something that the new regs will address. I'll tell you, when we have new regs, this is going away. Right now, it's a problem. The rape shield standard does apply in K-12 schools. Schools and parties can't ask questions about the victim's prior sex life, prior sexual disposition, predisposition, whether she's had 10 prior partners or none. That's irrelevant unless that evidence is being offered to prove someone else committed it, or the evidence relates to the complainant's prior sexual behavior with respect to this respondent, and it's being offered to prove consent. So those are the two exceptions. Schools must send a written decision simultaneously to both or all parties. That's K-12 and colleges. They have to specifically describe the school's conduct code sections that were violated and spell out what their actual findings and conclusions are. They have to explain their reasons for determining every allegation, their reasons for the sanctions that are being imposed or the remedial measures that are being required, and explain how to appeal and what the bases for appeal are. So the regs specify in more detail what the bases have to be, and then they're giving more discretion to schools to add to those, but we're not going into that much detail about those today. So something that's new, and this applies to K through 12s as well, is that the written decision must disclose if accommodations were offered to the complainant. This is the direct opposite of the guidance that was repealed by the new regs, which did not let schools inform the respondent. The respondent doesn't need to know what accommodations were provided to the complainant. It's really none of their business. And I feel sure this is going to go away as well eventually. So I did list the required grounds for appeal for you. You know, these are really just grounds that must be permitted, and then K through 12 as well as colleges can add additional grounds. So I'm trying to get to the time for question and answering. Oh, guess what? We're there. Great. So little poll before we go into any questions that you have. Do you feel like knowing how the Title IX process works helps in creating prevention materials, or do you feel like really, you know, the new process doesn't really impact the way you do prevention materials? Oh, that's interesting. Looks like the majority of you think it is helpful to know what the process is going to be when creating prevention materials. So thank you for answering that that poll. Okay, so I think that now we can open it up. You can unmute yourselves if you want to ask questions. You don't have to do it in the chat box, but are there some questions piled up first in the chat box?
Yeah, just a couple. Maggie asked, when you say the new regs limit what can be done until a finding is made, how does that limit accommodations a student can request in the meantime, such as a transfer of courses?
So there's certain accommodations, and they're on that slide that I had going back about halfway through the presentation, that the regs specifically say are okay to do before there's a written determination, and that includes class changes. But there are other accommodations that might more directly impact. So that would be a class change for the complainant, but the new regs might view a class change for the respondent to be a problem before there's a written determination of responsibility. So take a look at that slide, and if you have any questions about, well, you know, is this accommodation going to be viewed as discriminatory against a respondent or not? Those are the kind of questions in particular situations you have to consult the legal counsel for the school.
And then another one I'm seeing coming up from before is about forms, intake forms, appeals forms. Do people need to create their own forms? Are there templates available somewhere?
Well, the regs don't create any templates. If the Office of Civil Rights has some up on their website, I don't know for sure. You could check the website for the Federal Office of Civil Rights to see. I'm sure there's plenty of templates out there, though, that have been created by various schools, certainly by the CSUs and UCs, that they would be willing to share. But at the K through 12 level, I don't know who would be doing that or how they would find out what school districts might have already done that. It's a good question, but I don't know the answer.
Okay. And then we know that students, that international students studying abroad are not any longer protected under Title IX. Are there any other protections for them?
So again, that's where it comes down to the school's own conduct code and whether it protects its students. So let's say we have a foreign exchange student from high school going to a program abroad. That high school needs to have its own conduct code that would regulate all these things: sexual assault, domestic dating, violence, and stalking. Campus at its campus, or that apply to its students who experience it abroad. And then if they have somebody that's related to the school that they can adjudicate in a situation abroad, they can have a, they can have a grievance process under their own conduct code. Or if it's not, if it's some sexual assault that's not part of their that's not part of their educational program, abroad, but that impacts the student that's studying abroad, the accommodations can still be implemented and apply to that student abroad under their own school's conduct code.
Okay, thank you. And I think I've got everyone's from here. So please do unmute yourself or raise your hand or put your question in the chat. Or you can private message Sarah, Magna, or I to ask your question. Kelson, you had a specific question that I thought I would save to the end that was related to one before, if you want to unmute yourself and come on.
Sure. Thanks, Jessie.
Yeah.
Hi, Janet. Thank you for this. It's really informative. So I asked a question earlier around what was considered appropriate response. Definitely, yeah, it makes sense about it matters what the action that took place. So
Right.
in my case, it was the idea of leaking someone's nudes and just, the illegal sharing of, the non-consensual sharing of sexual images and videos. Basically, there's been multiple accounts on Instagram specifically made towards exposing other students' nudes. So my client, who didn't have their nudes on there, but a bunch of friends, and just different accounts, different versions of accounts have popped up over the past year, where we've let the administration know, and they said they were on it, but more kept popping up. So I totally know it's hard to pinpoint who's responsible behind Instagram accounts, but I was just wondering what is considered, in that sense, appropriate response.
Yeah, I don't know. I mean, you got to first identify the people or person responsible for the post, right?
Mhm.
Once they have the ability to pinpoint who's doing it, I think, the initial appropriate response is probably, I don't know. If it was one incident, maybe counseling and, some remedial programs. But if it's repeated incidents by the same person, the school's going to have to progress to more serious sanctions, I would think.
Yeah, that makes sense. It feels like, I guess, again, yeah, we don't know who was responsible because it was all behind a private account or an anonymous account. But the students really feel it was a group of people who have collection of pictures.
Is it easy to create an anonymous Instagram account?
I think so. It's just through any email, so you can just make one up. Unless they went that route to really backtrack who the email was located from. But it could be any random email, any new account under any name.
The cops could easily trace that. I don't know.
Yeah.
I don't know about schools.
So that's what I was wondering if that was an appropriate response to get to that level of police being involved.
Well, if it's happening repeatedly and they think it's one group of students that are probably responsible, I'd be turning it over to the cops at that point. I can tell you from a personal incident, a young relative in high school, who shared nude photos stupidly with a boyfriend who posted them, and the cops came and talked to both of them. And no charges were filed, but that's definitely going to have a chilling effect on anybody engaged in that kind of behavior.
All right. Thank you so much.
I have another question in the chat. Can you talk just a little bit about the major differences between behaviors that trigger a Title IX report and behaviors that trigger a mandated report to CWS, to Child Welfare Services?
Child Protective Services.
Yeah.
Well, Child Protective Services reports are mandated for any kind of abuse or neglect of a minor. So a mandated reporter would have to report, physical abuse as well as sexual abuse, dating, domestic violence, or stalking. Title IX applies it doesn't apply to just physical abuse. It doesn't apply to neglect, unless that physical abuse is within the context of domestic violence, dating violence. Now, domestic violence is defined pretty broadly in California, so family violence is included in the definition. But if it's just battery, but it's not sexual battery by a person who's not related to the child, then there's not going to be any Title IX implications.
And let's see, hold on. Does anyone else have a question they want to ask? I'm just trying to check on our list, but I want to make sure the floor is open. I'm getting some questions in chat. What are your thoughts, Jan, on when for an organization to hire a Title IX attorney to support questions around their prevention work on campus or supporting clients that are in schools?
So an attorney to help draft policies, do you mean, or an attorney to act as an advisor during a Title IX proceeding?
An advisor during a Title IX proceeding.
Okay. Most schools can't really afford that. That's going to be really expensive. So unless probably what most school districts will do is to maybe have an outside counsel or even in-house counsel, if they can afford it, provide advice that can, or training for administrators or faculty who are willing to act as advisors, who then can consult with that attorney. But I doubt if most schools are going to be able to afford to actually appoint attorneys to represent survivors. It's just going to be it's going to be very costly to do that. I'd be interested to hear if any school districts are doing that.
And
Yeah.
what about for policy? I think a lot of our prevention programs are assisting schools to look at Title IX policies or procedures, or how those policies get implemented, or how to make sure that students and staff know what those policies are, how to initiate a report. I mean, is it pretty safe to be able to follow a best practice policy and use that to leave it up to schools counsel? I know districts have their own legal counsel, or to help on our end.
I think it's really helpful if we can provide input, because the attorneys aren't thinking about it from the point of view that we think about it. We're thinking about it from what is going to help the survivor get through this, and we're thinking more in the framework of how can this help a survivor tell her story or his story, whereas attorneys are only thinking about liability of the school district. That's their job. and they're not thinking about it from other perspectives. So to the extent that there can be a collaboration in looking at the policies that are drafted for K through 12 schools, it would be much better.
Other questions? I just happen to have a list of questions that people have sent, so I can keep going with them, but I don't want to keep someone online from asking. But there is a couple of questions about differences between procedures for Title IX violations versus school conduct code violations. And also whether there could be conduct violation proceedings and Title IX proceedings both going at the same time.
Well, theoretically, yeah, there could, because Title IX, there could be some acts that fall under Title IX and other acts that fall under the student's conduct code, but not under Title IX. So it's possible. I mean, yeah, it's definitely possible that there were a series of events that, you know, that weren't all at the same time, maybe, that have to be adjudicated, and some are under the school's code and others are under Title IX. That's, yeah, it could happen.
And so another question that could open a can of worms is, are there conflicts between Title V and Title IX?
So I'm no expert on Title V, I just have to say right at the outset. There are definitely some conflicts with the new regs and faculty and staff contracts and union agreements with unions that are causing headaches all over the place. But I really can't address Title V.
Can you give us the name of what Title V is for those who don't know?
No, I don't even know what it is, really.
Okay.
I don't do educational law, you know, I do Title IX. So yeah, somebody who's an expert in education law should know Title III, Title V, or Title IX, you know, they'd know them all. I'm not even sure if Title V is the one that governs employment contracts like I was just talking about, because I was sitting here in my head running that over. Is that Title V or is that a different? Yeah, so no, got the wrong person for that question.
And does written notice of every meeting, does that include giving notice to families ahead of time? The schools, this question, they elaborated and said that the schools just tend to pull students in, you know, just whenever, but not give them notice that they're going to be talking to them. Is that?
That's going to be problematic under the new regs, which say the parents can act on behalf of the students. So I think that they're not just going to be able to pull a student out of class without telling their parent or guardian that they're questioning them. I think the new regs, because they give so much authority to parents to act, the parents at least would have to have the option of being there.
Well, folks, questions are on you now. I just ran out.
Well, then everybody gets to go home early.
Well, hopefully I got everyone's questions in the chat. Meghna and I were working together to capture them. So if we missed it.
Well, if nobody else wants to unmute and ask a question, anybody can email me through Calcasa. Let's see, the last slide. Somehow it's not, no, it's not moving ahead.
And we do have a survey for you all to fill out. So I just wanted to go ahead and plug that really quick. So that would be an excellent use of your spare 10 minutes. I'm going to go ahead and
Oh,
Yeah, and if anybody has
put your link in the chat.
any other questions too, info@calcasa.org, just send it to me, care of that, and I'll get back to you.
I have another question that's come in, and of course, y'all don't, you can come unmute. I just assume if you're putting in the chat, since I'm on a roll. When
Jesse.
speaking to students about Title IX, what should be the key points that we tell them? And does it differ from district to district, or if we're providing? I'm assuming that we're talking about if we're doing education in schools about what Title IX is, and that it's there for them. What are the key points?
I guess the key points are that, if they experience any of these things that are covered by Title IX, that if they're, if they report, they'll both have the option to receive any accommodations that they might need to get through the experience, and that they will have the option as well to go forward with a proceeding that will determine whether sanctions should apply to the person that was responsible. I think that's the main thing. I don't think you have to get a lot of technical stuff in the materials for K-12 students. Just that, there's a process that'll make sure that they're safe, that they can successfully finish their schooling, and that if they want to proceed with a determination that governs responsibility, that sanctions will, apply to the person who was responsible. I think those are the main things. I don't think I don't think they need to know a whole lot about the fact that Title IX versus non-Title IX, as long as the school's conduct code is going to deal with any sexual assault that occurred outside of the Title IX context. They just need to know that they can be addressed. I hope every school will address a student's ability to get an education, even if a sexual assault happens to them that's outside of the school's program or activity or similar conduct.
I see a question here from Kay, curious about what the law says about actual primary assault and violence prevention activities. Kay, can you help me out with the question in here? How do preventionists work on prevention instead of response? Are you thinking in like looking at policy pieces or?
Well, yeah, that's true. That prevention is looking ahead to, try and stop it before we have to talk about response. And like I said, not a lot has changed on the affirmative consent stuff. It's, you're still talking about affirmative consent when you talk about prevention. Yeah, so I don't know. The prevention materials, to the extent they're truly dealing just with prevention and not with the school's response to sexual assault, probably hasn't changed that much in what you're talking about for true prevention. Not sure if that answers that question.
We'll give Kay a minute to come on to unmute herself. And if she
Hi,
wants.
this is Kay. I guess when I read the invitation on this webinar and I saw the word preventionist, I thought we'd be talking about what activities people were doing in K-12 to prevent the need to refer to a Title IX process. And so to me, it feels like preventionist, a more apt name, and not being unkind, but maybe they have this as part of their jobs, would just be responder, is what it feels like to me. So anyway, I was just curious about and I realized from Janet that there may not be any legal basis or requirement that there be prevention activities, but just curious, kind of what preventionists are doing on that other side to prevent sexual assault and sexual violence.
Oh yeah, Kay, a lot, this training rose out of, when folks are on campuses doing prevention work, teaching healthy relationship skills and consent and all of the different things that they're doing on campus, inevitably they get a lot of disclosures. And so being able to work through, how to support folks in that school system are just questions that inevitably come up even when we're working toward preventing violence from happening in the first place. We're often the first ones that folks disclose to, which is where we saw the need from the field of preventionists for this training.
Got it. Okay, thank you. That clarifies it.
Sure.
Appreciate it, Jessie.
Yeah. Right. And John says, yeah, the law and regulations say very little about prevention, like comprehensive sex education,
Right.
affirmative consent. So often, where our folks are the ones in there doing that work. Other of our partner agencies that we often work with, like Planned Parenthood, and hopefully some very good health education teachers on campus.
Yeah, because health ed looks like mostly where you're going to get any prevention education in high school. I know I tried a few years ago to get some of the local high schools to let me come in and do some prevention work at the high school level in Sacramento, and all of them said, sorry, we don't have time for that. Yeah, we're too busy making sure that we check all the boxes for the standardized testing they have to do.
All right, well, here we are at 3:58. I want to take a minute to go back and plug the survey again that Sarah put up in the chat. We really look at those comments and appreciate your feedback. So please do go to that SurveyMonkey link on your way out. If someone, Sarah put it back up, so it's right there handy for you. If anyone has any questions that they didn't get to answer, we can let everybody else go and say goodbye and have a wonderful week. And if you want to stay on for just a minute, that's okay. And otherwise, we are done. Yeah, Sarah, Jan, Megna, anything?
That's good. Thanks for being such an attentive audience. I didn't hear a peep.
Yeah, thank you so much for joining us, everyone. Like we said, if you have any other questions regarding this subject or any other training and technical assistance needs, you can feel free to reach out to us at info@calcasa.org. And we will be sending out the recordings from this web conference just in the next week or so. So stay tuned, and thanks so much for being here with us today.
Take care.